Hello. Welcome to the third installment of Emerge Law Group's webinar series, which we call Deep Dive into the Oregon Psilocybin Services Act, aka Measure 109. We've done two of these we did one in January, we did one in February. We're going to do them every month for the rest of the year to kind of just, I think what we want to do is we've structured this so that we kind of pick a topic for the month and we try to get into it a little bit more than just kind of a very general view. And then we've also tried to, this is scheduled for 2 hours. It sounds like a long time, but we've tried to leave plenty of time for questions and answers and comments and banter and a real free-flowing discussion. So in the past two webinars, I think the presenters were done in 35 or 45 minutes, and then we had a pretty good hour plus of talk on all types of subjects. So I think we're going to probably try to keep doing that today. Today's topic is land use in local jurisdictions. I think our client base, we're starting to get questions on this topic. This is obviously anyone who is involved in the cannabis industry knows the importance of land use compatibility statements and local jurisdictions. This has not been a very hot topic for the Oregon Health Authority to date. The Psilocybin Advisory Board, which has been discussing all kinds of things for the past year, has barely touched on this issue. But I think the timing here is right because we're getting a few clients who are thinking about, this is the year when when clients are going to start forming businesses, raising money. They got to lock down property and they're going to be applying for licenses in January. So it's not too soon, I think, to start thinking about this issue. Corinne, our land use attorney, has reached out to several local jurisdictions already, and it seems there's a big learning curve on a local jurisdiction level. So we thought it was high time to sort of put this thing together. I'd like to introduce my colleague, Sean Clancy. Sean, I guess I'll introduce myself first. I'm a business law attorney by trade. I was a primary drafter of Measure 109 and have been sort of intimately following the Psilocybin Advisory Board and working with clients. Sean Clancy is my colleague, business lawyer, intellectual property attorney. Sean was part of the Measure 109 drafting team, so he was there at the very beginning of this Measure 109, the version of 109 that passed, and was very instrumental in kind of helping out with that. Corinne Celko, my colleague, will be sort of one of the stars of this show. Corinne joined Emerge right when Measure 91 passed for cannabis and was thrown into the crazy days of early cannabis and dealt with lots of local jurisdictions and land use issues back in, I guess it was 2016, 2017. And Rob Bovett, our great guest speaker today, I'll let Rob introduce himself when it's his time. I met Rob back in the early Measure 91 days when he was representing the counties, and Rob was always all over the legislature and the OLCC, and we've had a lot of good talks. So I asked Rob if he would be willing to talk on this issue, and he volunteered in 2 seconds. So it's great to have Rob. I think I'll just turn it over. Sean is going to kind of serve as our MC and traffic director today. And so he might give you some ground rules on that. Go ahead, Sean.
Great. Thanks, Dave. Thanks, everybody, for joining us today for what's going to be a very interesting discussion, I'm sure. So yeah, a few housekeeping and ground rules for the Zoom format before we dive in. We're recording this event and we might post it online. However, we do not intend to use any of the audio or video from the Q&A session at the end. So that portion will not end up online. We ask that everyone remain open to all of the viewpoints expressed today and being respectful of others, keeping in mind that reasonable minds will differ on some of the topics discussed today. Also, to be mindful of the amount of time you're taking up when you're speaking. If you're speaking during the Q&A exchange session, we'd like to get to as many questions and comments as possible. We don't anticipate having to use the mute function, but we do have the ability to do so if you're being disruptive or making noise. We've allocated 2 hours for the event today. So we hope to have an extensive and lively Q&A exchange at the end. We have quite a few participants, so to keep everything as streamlined as possible for the questions and comments, the procedure that we'd like you to follow is either state that you have a question or comment in the chat box at the bottom, or if your question or comment is concise, you can just type it out in the chat box. You can also raise your hand using the reaction button with Zoom at the bottom of your screen. But if I missed your raised hand, the chat box is kind of the ideal method, and I'll be kind of keeping a queue of who's wanting to speak or ask questions. So yeah, like I mentioned, the Q&A will be at the end of the presentations. So please try to avoid speaking out of turn. When you do ask questions, try to avoid asking fact-specific questions. We're not anybody's lawyer during this presentation, so please don't ask for legal advice or give anything for your specific situation. The purpose of this event is more to educate and provide general information, not to address your particular circumstances. If you're camera shy, or if we run out of time and we don't get to you, we do have an email for fielding inquiries. It's m109@emergelawgroup.com, or measure 109. I'll drop that in the chat box for anybody who wants to send us an email. We have these events on the last Thursday of every month during 2022, so mark your calendars. And if you have suggestions for future topics, feel free to send those in the chat box or to that email address. But other than that, I will turn it back over to Dave.
So right before we turn over to Corinne and Rob, we were talking beforehand. I've attended a lot of Measure 109 talks, and I've given my fair share of them. And I wanted to do this deep dive series, or call it that, because again, I wanted to sort of just not do this broad general overview. I wanted to sort of go deep. And so in the first two, I didn't really give an overview of Measure 109 because I kind of assumed like everyone knows what it is. And we're not here to sort of explain the things in broad strokes, or just run through. The act is very long. It's 134 sections. It's 75 pages long. Like, you could just spend 3 hours going through the act, provision by provision. But I just wanted I assumed that every folks had some basic knowledge, and we were just going to get into the details. Here, I think, because I think we have some new folks here, and even Rob himself was catching up to speed on this issue. So Rob and Corinne asked me to give a 2-minute spiel on Measure 109. So this may be old hat to some people, but Measure 109, and this is a very short version, is basically legalizes psilocybin products and services under state law. Psilocybin is a federally controlled substance, just like marijuana. And so it's the same, in that perspective, it's the same. Federally illegal controlled substance legalized under state law, under a regulated system. Instead of the OLCC, the Oregon Health Authority is the agency we have here. Much like cannabis, the OHA there's an application process, and there will be licensees. The licenses are a little bit different than the OLCC's cannabis licenses. There's 4 different licenses under the Oregon Health Authority, or under Measure 109. One is a manufacturer license. That is sort of a combination. In cannabis, we have producers and processors and wholesalers. Here, we just have manufacturers, which is combination, cultivation, and processing. There will be different types of psilocybin products, and a particular manufacturer may have several endorsements yet to be determined by the OHA, but it's all one manufacturer license. That's for the creation of the products. Then you have the service center operators. Now, this is a very unique thing, I think. I would say it's a combination of a retail establishment. This is where the client, who is the consumer, I suppose, but under the act we call them the client, will walk into the service center, purchase the psilocybin product, and consume the product on site under the supervision of a supervisor, under supervision of a facilitator. So very different than cannabis in that respect, where nobody's going to walk into a store, buy a psilocybin product, and walk out of the store and go home. Everything's going to happen at the service center, and the client won't go home until the entire experience is over, which, depending on the dosage and depending on lots of other factors, could last a short period of time, or it could last 8 hours. Somebody could be there all day long during a session. So, and then we have facilitators. Those are the individuals who will be supervising the sessions. Facilitators are an individual type of license. So just like I'm an attorney, a facilitator has their own license individually, and it's not tied to any piece of real estate. And they can work for service centers, or they can be freelance independent contractors, or do whatever they want to do, but they can essentially be mobile folks who move around. And then finally, we have laboratories. The laboratory section is basically right out of the Cannabis Act. So we've got manufacturers, service center operators, facilitators, and laboratories. And I think for the bulk of the land use talk will be about the manufacturers and the service center operators. There are sessions that take place. There's something called a preparation session that happens. It's basically a conversation between the facilitator and the client. It will happen before the administration session. The administration session is when they purchase the product and consume the product and experience the effects of the product. The preparation session happens before that. It's a combination, or it's a conversation that basically, again, the OHA hasn't come up with rules on this, but the intent of it is that it would be kind of an introductory discussion to see if psilocybin, if the facilitator wants to work with the client, and psilocybin is a wise choice for the client. So there'll be a procedure for that. And there's something called an integration session, which is kind of a follow-up conversation, which is essentially voluntary on the client's part. But those are the various sessions that will take place. But I think the focus today, of course, is land use, and we're very interested to see how this might play out from a manufacturer standpoint and from a service center operator standpoint. So that's the basics. Anybody can ask questions on the more details later on, but now I think we can turn it over to Corinne and Rob.
Thanks very much, Dave. Good afternoon, everyone. So pleased to be here and see all of you and have a chance to have a dialogue with you all today about Measure 109, land use in local jurisdictions. Before we get started, I'm thrilled to be here today to present with you with Rob Bovett. Rob, would you like to give a brief introduction?
Sure. My name's Rob Bovett. I've been a county lawyer for about 30 years. I want to thank Emerge and Dave for allowing me to be here. I think this is really just the beginning of a conversation, because we're going to have this conversation throughout the rest of the year. Just to let everybody know, I only have one client, and it's not you. So I don't have any clients here. And I'm not really here to, kind of as Dave alluded to earlier, I'm not here to encourage or oppose really anything. I'm just here to primarily talk about some of the local government options that are baked into Measure 109, which Dave crafted. And thankfully, he pretty much cribbed what we worked on out of the cannabis statutes that I crafted in 2015. So essentially the same operative language. But there are some important differences that I'll highlight as as we continue to talk. I know there are a number of local government lawyers here that remember Measure 91 implementation. A lot of it will sound familiar, but there are a few key differences that we'll touch as we go through the slides. Anyways, I thank you for having me here, Dave and Corinne. I appreciate the opportunity.
Okay, thanks, Rob. Well, so, let's dive in. This wouldn't be a presentation without more disclaimers. So, really quickly, the reason we're here today is not to give legal advice at all, but rather the information we'll be providing is for educational purposes. So with that out of the way, why are we here? Why are we talking about land use? Why is land use important? I know that Dave mentioned it hasn't been a hot topic with regard to Measure 109. For me, it's always a hot topic. And one of the reasons is because they're not making it anymore. So it's a hot commodity. And the state of Oregon and local governments have great interest in helping determine how uses within their communities are being used. I think importantly for today's purposes, we're talking about land use in local jurisdictions because Measure 109 applicants specifically for licenses for manufacturers and service centers, not only will you be required to obtain a license from the state, but you're going to have to comply with local government land use regulations as well. So that's what we're here to talk about today. Just to give you a little brief overview of what we'll be discussing, I'm going to do a real quick background on Oregon land use structure. I think as Dave mentioned, we have a variety of folks in our audience today. So just would like to establish a baseline so we're all sort of on the same page about the background of land use in the state. We'll move on to talk about specific Measure 109 land use provisions, and then how local governments might treat Measure 109 uses and what sorts of restrictions or limitations might be put on them. We'll talk about ways in which operators can participate in local government processes. That's a really important part of this. You'll hear us talk, I think, a lot about collaboration and education and participation. Lastly, we'll cover the takeaways from this slide and then move on into the Q&A. So Oregon land use structure. I know that for the local government folks here today, seeing the phrase Senate Bill 100 might scare you. I don't mean to scare you. I'm going to say like 2 seconds on the topic. The only thing I'll say about it really is just that, back in the 70s, Oregon wanted to kind of take control over what they saw as maybe some sprawl into some resource lands, and wanted to make sure that this precious resource of land was being put to good and efficient uses. So at that time, Oregon required comprehensive land use plans and zoning ordinances from each of the local governments, each city and county. And those comprehensive plans and implementing zoning ordinances needed to meet these broad statewide planning goals. And, with the exception of really some resource lands, which are farm and forest lands, the state has given local governments, fairly broad discretion over how they plan their communities. What Senate Bill 100 did, though, was require that each city and county have a local zoning and development ordinance. And in that ordinance, they would establish the community zoning. So, retail, commercial activities should occur in this zone. Residential uses shall occur in this zone, which are far apart from with the industrial zone that should have more, manufacturing uses. Zoning codes and development ordinances also establish which uses can be made within each of those zones. And lastly, broadly, the zoning and development ordinances establish what sort of development regulations each local government requires. Those can be things like setbacks, height requirements, density, things like that to make sure that the uses within each zone have the right scale to them. So that's just a brief background of how the state of Oregon has set up its land use structure. And I think it's helpful in when we move on now to talk specifically about Measure 109 uses and how those can fit in to the local government land use structure. So the way that Measure 109 has started to relate to land use, one of the first things that Measure 109 requires with regard to land use is for manufacturers and service centers that are, for manufacturers and service center operators, those licenses are tied to real property, as Dave mentioned. And one of the requirements for a license for each of those types is a land use compatibility statement. And showing here now is the second page of the land use compatibility statement that's required for cannabis operators. And the reason why I'm showing it is because I imagine that it will be similar, if not identical, to what was required for Measure 91 and for cannabis. So, Rob, you've seen this. You helped create the land use compatibility statement. There's two boxes here that a local government can check. They can say that the proposed land use has been reviewed and is either prohibited or not prohibited. Can you tell us a little bit more about how you've seen local governments use these land use compatibility statements?
I'm sure. Maybe a little history here would be in order, especially since there's some folks here attending that are real familiar with how the Lux works in the cannabis sector from a local government standpoint. So back in 2015, when we crafted that Lux statute, I really wanted it to have three checkboxes. One for outright approved, one for prohibited, and one for could be approved if you got a conditional use permit or jump through any other hoops that were required. The state didn't really want to do that. The industry wasn't keen on it either, but the state in particular didn't want to do that because they wanted to be able to have the state agencies just be mostly administrative. So if they got a Lux with the box check prohibited, they just would deny the issuing the license. If they got one that said allowed, even if a conditional use permit was still required, and they would be able to issue the license. Essentially, they wouldn't look behind it. And if the person didn't subsequently get the conditional use permit or follow the conditions that the local government inserted in that comment box you see there, then it would be up to local government to enforce against that rather than the state. Now, baked into the statute, however, is another option for local government, which is just to simply not issue the Lux in a conditional use permit type setting until the conditional use permit is actually issued. And you have 21 days to either issue a Lux based on checking either of these two boxes or not issuing at all if a conditional use permit is required. So you still have functionally the same options with Measure 109 statute as you have currently with your cannabis statute. It's not the way I wanted the Lux statute to read, but it is what the state is willing to enforce and utilize, and that's the statutory language we've been using. Now, I should mention there was a time when some cities, I think, I'm not aware of any counties that did this, but I think there was a time when some cities who had, for example, a conditional use permit requirement in a particular zone for an applicant, they would check prohibited, but then note in the comments section, well, if you got a conditional use permit, we'd give you a different Lux that said allowed with the conditional use permit. And the Court of Appeals back in December of last year basically interpreted and applied the cannabis statute and said you can't do that. If you have a conditional use permit that's required, so the applicant has to go through hoops, then you either don't issue it and wait until it issues before you issue the Lux, or you check the box is not prohibited, and then you add all the conditions below, but then you have to enforce it. So anyways, I didn't mean to get into all those weeds, but the point is that the Lux, I'm guessing, will work identically to the way it works in the cannabis system right now, because the operative language is precisely the same. And I think our Court of Appeals cases that have interpreted the Lux standards will apply equally, because I can't see any difference in the operative language. So mostly for the local government lawyers, I think if you talk to your planning folks and they're comfortable with how the Lux works in the cannabis system, I think they're going to be very familiar with how it works in the OHA system.
Thanks, Rob. Makes a lot of sense that this would be sort of the same setup. And I also have seen local governments treat these land use compatibility statements in different ways. I have seen where local government will check the box that says, is not prohibited, and then make the comment that a land use review is required, but allow the applicant to essentially go through that land use review contemporaneously with the state license application review. And that has worked out well, because as you know, those processes can take a long time. So to be able to do them contemporaneously is helpful.
But again, I'll just have to chime in. If you do that, if you allow that contemporaneous tandem, I say if the local government allows that to occur, then the Lux really isn't an enforcement mechanism, because if the applicant just ignores the fact that they need the conditional use permit and just takes the state license and opens up shop, then it will be on the local government to enforce against that. The state won't do it.
Right. Okay, so again, for this point, the land use compatibility statement, this is something that manufacturers and service center operators will be required to have in order to obtain a state license. Continuing with some other land use provisions, land use related provisions contained in Measure 109. A psilocybin service center is expressly not a healthcare facility, subject to a different chapter in statute. Not sure that this really has a lot of implications for local government zoning and development codes. I think it's more of a chance to recognize that psilocybin service centers aren't subject to these other license requirements that specific healthcare facilities are subject to. The next Measure 109 land use related provision is that psilocybin service centers are prohibited in exclusively residential zones within city limits. And it might be relevant at this point to sort of explain that when we talk about local governments or local jurisdictions, we are talking about, if a piece of property is within a city limit, then that property is governed by the laws of that city. If the piece of property that you're looking at is located outside of city limits and in the unincorporated county, then it's governed by the county's laws. And that's true even if, like the city of Portland is located within Multnomah County. But again, we're looking specifically at the piece of property and whether or not that lies within a city limits or outside of a city limits. So that provision is just what it is. They don't want service centers in exclusively residential zones within city limits. The next land use related provision is also what it is. It's a buffer, and this was a buffer that was part of Measure 91 for cannabis. And this is where a psilocybin service center is prohibited within 1,000 feet of a school. What I say here, there are exceptions, and those are only meant to allude to the fact that, the Measure 109 does include a provision that states that if there's some sort of barrier between the service center and the school, a river, a mountain, a highway, maybe something like that, there would be an exception to that 1,000 feet rule. And then the other possible exception is that if a service center is established on a certain piece of property, and then after it's been established, a school comes in within 1,000 feet, that service center is essentially grandfathered and can stay. So the ones we've mentioned so far are pretty direct. This next one, I think, can be, cause for a lot of discretion among the local government. And what Measure 109 allows is for local governments to adopt reasonable time, place, and manner regulations. And Rob, when we talk about reasonable time, place, and manner regulations, what are some of the considerations you think that local governments think about when determining which time, place, and manner regulations to implement?
Well, I think it varies from location to location and the concerns that are expressed within, say, a city or a county. I think a few things are important to note, especially for the practitioners on this call. The time, place, and manner regulation language that Dave used in Measure 109 is, again, functionally identical, the operative language, to what you'll find in the cannabis statutes. And so there is a little bit of case law, some that actually Corinne developed out of Deschutes County, another line of case law out of Jackson County as well, helping to interpret that. But if you go back into legislative history, you'll find that this particular section and its origin didn't come from Measure 91. I crafted it together with a colleague of mine, Scott Winkles from the League of Oregon Cities, to provide for this authority for cities and counties to supplement the state regulations at a local level. And so what that looks like varies pretty widely from jurisdiction to jurisdiction. And maybe if I could back up a little bit and talk about the context of the time, place, and manner regulations, because of course, place, the P, is really land use in a way, or can be land use, and is a lot of what Corinne's litigated under those statutes, are land use actions. But so some, for example, back in when Measure 91 was first implemented, some counties and cities changed their community development codes, their zoning ordinances, because they needed to tune them up to deal with these new types of businesses. Others didn't, because their existing codes were just fine. And we found since that time, they were just fine and they're working just fine. Same is true for time, place, and manner regulations. Some folks may have general business regulations in place that control things to the extent that the city council wants or the board of commissioners wants, and others don't. So what we saw happen among the 36 counties and the 241 cities in Oregon after Measure 91 was first implemented was really a kind of a variety of things in different communities, because, as Corinne already explained, the land use plans in any county or in any city are very unique, with the exception of some commonalities with resource lands. If you've seen one county zoning plan, you've seen one county zoning plan. So in terms of what needs to be supplemented, whether it's in the zoning code or if it's through a separate time, place, and manner ordinance, is really going to be different in different places, because it truly is the supplemental regulation to fill out the gaps created by essentially our land use system, which is dispersed. It's not statewide. It was statewide, but it's not state controlled at every level. So that's a long way of getting around in saying that I suspect that a variety of cities are going to do TPMs and a variety of cities are not. A variety of cities are going to do land use code changes and a variety of them are not, just like we saw in Measure 91.
Yeah. Thanks, Rob. So, I think it's helpful to point out here that there's a couple of places where operators need to be paying attention to codes, and that is, with regard to zoning and whether or not a particular use would be allowed in the zone. But then there's a separate section, right, for the time, place, and manner regulation. So even if even if a psilocybin service center will be, or a manufacturer will be allowed in a specific zone, you got to make sure to check the time, place, and manner regulations to make sure that you're also complying with whatever those may be. And again, we're sort of analogizing to cannabis because that's the only other remotely similar thing that we've dealt with. And again, Measure 109, the language of Measure 109 in some places is similar to that of Measure 91. And the sort of time, place, and manner regulations that we saw with cannabis were things related to hours of operation, were related to other buffer distances. So the state has put in the 1,000, you got to be at least 1,000 feet away from schools. Well, some local governments could implement other regulations that required a psilocybin service center to be at least 1,000 feet away from parks or daycares or churches, things like that. So those are examples of time, place, and manner regulations that were adopted by some local governments with regard to cannabis.
And if I could just add one more thing, mostly just for the local practitioners, local government practitioners, unless OHA goes a different route, which they might, generally the TPMs are enforceable locally. So the Oregon Liquor Control Commission won't step in and enforce the types of time, place, and manner regulations that Corinne just mentioned, at least not directly. Now, if somebody persistently violates, we can complain to OLCC and it can have future ramifications, but OLCC is not out there enforcing our TPMs. That's really up to the cities and counties to do. I just wanted to make that note because I suspect that's the way OHA will treat it as well.
Thanks for pointing that out. Okay, well, we'll talk a little bit more about potential time, place, and manner regulations with specific regard to Measure 109 uses. Let's finish out some of the land use related provisions in Measure 109. It says that psilocybin producing fungi is a crop for farm use purposes. And I think the implication for local governments there is that manufacturing, growing of psilocybin producing fungi will be allowed on farm use land. I think that to the extent that an operator would like a manufacturer license as well as a license for the psilocybin service center, finding zones in which both of those uses are allowed will be something that you'll want to look at. And then finally here, one of the last land use related provisions in Measure 109 is the ability of a local government to opt out and to opt back in. Rob, do you want to explain a little bit more about that?
Yeah, and maybe I'll spend a little bit more time here because this is the same in some ways as what folks experience with Measure 91, but it's different in other ways. So let's go back to 2015. And then there's both some good and bad news here, but let's go back to 2015. We were kind of scrambling at the time to figure out how we were going to set a baseline for what's the default setting. For example, if a county in Eastern Oregon or versus a county in Western Oregon, say the Eastern Oregon County really didn't like Measure 91 and they wanted to start with a default that said, no, we're opt out unless the voters opt us in. And what we're talking about now is just the businesses, because we're talking about opting in and out of marijuana related retail businesses. And so what happened mechanically back then is we had kind of a breakdown. In June of 2015, we finally got the legislature back together and focused in on this particular issue. And we worked literally a handshake deal. I won't tell you all the nitty gritty, but it involved a 30-second elevator ride and we figured it out. And the deal was basically this, and it's going to seem weird, but there were actually two precedents for this. We basically said, if you're a county or if you're a city in a county that voted no on Measure 91 by more than 55%, your default setting is basically going to be you're opted out. All you have to do is enact an ordinance, you're opted out unless the voters opt you back in. And if you voted, if your county or your city in a county that voted yes on Measure 91 or no on it, but by a narrow margin, then we're going to treat you as default as opt in. So everything's open unless your voters say otherwise. And that set up a whole series of elections that occurred shortly after Measure 91 was passed in terms of folks opting in and opting out. We also had a lot of tax measures, which I won't bore you with. That is not the case with Measure 109. And the good news is there's more time, because those of you that were practitioners back in 2015 may remember we had virtually almost no time to call the elections or do the TPMs or do the code amendments. It was all just a jam. And that's because we didn't finish that until about July of 2015, and we had to do everything the next 6 months. Same timeline here, except we got more time because we're now having this conversation at the end of March. So we've got a few more months to play with here, but the timing is pretty much the same. So in terms of opt-in, opt-out, the default setting is important to notice. In Measure 109, everybody is opted in. Every city and every county is opted in unless your voters opt out in a general election, i.e. November of an even numbered year. So the same timing that applied to Measure 91 applies here. I suspect that local governments will be around Oregon will be examining and potentially making a whole series of decisions around Measure 109 in the summer, because there will be a deadline. Usually it's in late August, early September to get something on the November ballot, assuming that they wanted to ask their voters if they want to opt out, or if they want to do time, place, and manner regulations or ordinances. For most local jurisdictions, and most local practitioners already know this, it takes quite a while to get these things done. And so we essentially are going to need the fall to carry out whatever directives we get from our bosses in terms of what they want to see put in place and what questions they want to ask their voters. So again, very similar to what we saw with Measure 91, except the default setting is everyone is opted in. All cities and all counties are opted in unless their voters this November or some November of an even numbered year say we're opted out. And the same thing happens in reverse. You can opt back in through elections and opt back out through elections. And there's quite a precedent for that, going all the way back again to the Liquor Control Act of 1933.
And Rob, this should have probably been part of my elevator speech on 109 at the beginning, but and I remember that 2015 year when Measure 91 passed in 2014, and the legislature went into session and started to revise Measure 91. And then the OLCC kind of sat there waiting for the legislature to do its thing. And it wasn't until like July when we started to have rules, and it was very chaotic. And so, and there's a big learning curve for everybody. And I remember being very frustrated at the rules that came out in December, because it just from a business organization standpoint, I'm trying to put businesses together for clients, it was a little hectic. So for Measure 109, for a variety of reasons, including this, we have this 2-year development period, we called it, which essentially we thought was a good idea, given the history with cannabis, to kind of give everybody, the OHA itself, local governments, even the federal government, like everybody, a chance to kind of, in the legislature, to breathe a little bit and to see what this is about. And unlike 91, the Oregon legislature hasn't tinkered at all with Measure 109. So what was written stands, and now we're in sort of the second year of the 2-year development period. And the timeline is that by January, the OHA has to, by statute, begin accepting applications. So that's why I think the next, the last 9 months of this year, we're starting to sort of accelerate here into really kicking into the next phase. I think the first year of the development period was a bunch of brainstorming and talking and thinking, and now I think it's like the rubber's starting to meet the road a little bit. But yeah, that's why we just had the automatic opt-in, Rob, because we figured people had an opportunity to do it before January 2023 rolled around.
Well, and I got to say, just having the extra, 3 to 6 months tacked on without all the chaos of, well, and you may remember, Dave, there was a time toward the end of the 2015 legislative session, we thought the whole thing was going to crash and burn. And so we don't have that problem here. And I suspect the legislature didn't tinker much with the 109 language, because you use basically all the stuff we worked out for cannabis in terms of the operative language. So that kind of makes sense to me. So again, I think there's time for us to learn, and local governments to figure out what the best course is, because they can really spend the spring and summer kind of learning and thinking and then really late summer, making some initial decisions and carrying those decisions out throughout the fall and winter before the licenses start to issue in January. So thank you for that timing, because I think it actually works, and I think that's another of the lessons we learned from 91.
I mean, it is a challenge for folks who are interested in starting a manufacturing business or a service center business, because right now, if a client calls us up and says, hey, I've got my eyes set on a piece of property here, I think it would be really good with what I'm thinking of doing. And they ask our law firm, like, will this property work? Like we can't give a definitive answer right today. For cannabis in the early days, Corinne, kind of like, that's what people would do. Cannabis clients would call, but hey, I've got a property. We get the property address, Corinne jumps online, does her analysis, green light, yellow light, red light, and we kind of have an answer. Right from today's perspective, it's impossible for our firm, I think, to give a green light anywhere. There's too many variables out there. And while the local jurisdictions are using this time to think and to get their heads wrapped around it, that does put folks who are trying to start businesses kind of like, we're sitting there on the sidelines waiting for what might happen. So hopefully everyone's wheels will turn and we'll have some ideas of stuff, because if clients are calling us up in December saying like, oh, I've got my eyes on a piece of property, and nobody's in a position to issue a Lux, then the OHA can sit there and be ready to accept applications, but there won't be any applications, at least for manufacturers or service centers. Facilitators, sure, but so hopefully, the OHA is now structuring it, it's rolling out its rules with the idea that, a lot of things got to fit together here, and that nothing's going to hold anything up too much. I mean, one piece of the puzzle falls apart, the whole system could kind of come to a grind. And so that's just an observation and something we might have to be telling our clients repetitively for a while. But I look forward to the day when somebody says, hey, I've got an awesome piece of property, it's for sale, can I make a commitment and do it? And Corinne can do an analysis, and we can, with reasonable certainty, say, yeah, you're good here.
I see there's also a question that popped up, Dave. Are we confident that local jurisdictions are starting to grapple with this yet? Can't speak for all 241 cities or 36 counties. I can only speak for my own client. We're starting to grapple with this. We're looking at it. I suspect most are. That's just my suspicion. People are aware of this. And like I say, the really good news here is it's not as frantic as it was with 91. So I think there's time for people to engage in some thoughtful conversations with their community and with colleagues and figure this stuff out. Now, I will tell you that back in the day, and I don't know if this will happen this time around, but back in the day after Measure 91 was implemented and we finally got House Bill 3400 through after the House and the Senate got back together after their divorce, the League of Oregon Cities did produce some templates for various actions that we've already talked about here today. I'm not sure if they will again, but I have talked with their folks. I helped them with it the last time, and I'm not sure if they're going to put the resources into doing that again, but it may be something where we work up templates over the summer as well. It will be nice to have consistency around the state so that various practitioners can understand, okay, I've seen this before, here's what's going on. So to the extent that we can do that, that might occur. But again, this, to me, Dave, this is the beginning of the conversation. So Greg Kearns, I'd tell you the same. I think we're all starting to grapple with this. And the good news is we have time.
So that's a good segue. That's a good segue into the next topic here, which is, how are local governments going to treat Measure 109 uses? How are local governments going to treat manufacturers and psilocybin service centers? What is a psilocybin service center? what land use category in cities and counties are they going to fall under? Where are they going to be allowed to be located? How are they going to be regulated? This is the meat of the questions that need to be answered. And these questions are hard to answer without knowing exactly what we're dealing with. I'll give you a quick example. Back in the cannabis days, I remember talking to a county council in a county in which they'd had a zone that allowed edibles, cannabis edibles, but did not allow extraction or concentrates. And so I had this conversation with this county council who we had a great rapport. And I said, well, I'm just not quite understanding, how is a business supposed to operate? How can someone make an edible if they can't get the oil, if they can't get the oil to put into the edible? And he said to me, well, what do you mean? Don't you just crush up the flour, into the cookie and bake it? So there was just a profound disconnect, some miseducation about how the process works, and that for a business to be successful in what they want to do, they've got to be able to take the to extract the oils to be able to put into the cookie and bake the cookie. And I think, as you all have alluded to, Rob and Dave, that is the kind of dialogue that needs to be happening now. Rob, what are your thoughts on whether or not local governments know what a psilocybin service center is and how it's supposed to function?
And that's my question too. I don't know what these things look like. And I think it's kind of going to be incumbent on the folks that want to get into this industry to really help folks understand what these things are going to look like. Because, for example, Dave already described the 4 categories of licensees, and they're different. They're different than we've experienced with cannabis, but they're more combined. There's only 2 really that have a land use implication. And, Dave described the manufacturer as almost being a combination producer, processor, wholesaler. And I get it, it makes sense. But what does that look like on the ground? Is that just a greenhouse on a farmland? That makes sense, but is it something else? But I think the bigger question for me is, what do the psilocybin service centers look like? Because I could see something that looks like a health clinic, maybe. Maybe it could look like a resort. I don't know. And so I think those are the questions that people are going to have. I'm guessing that city leaders are going to have, county leaders are going to have. So I think it's going to be important for our local government leaders to kind of understand what all this looks like. And unfortunately, I think this is a little different than cannabis in the sense that I think there was generally a broader sense of understanding what the cannabis world kind of looked like. I mean, we were the first state to decriminalize less than an ounce of marijuana in 1973, the same year we enacted Senate Bill 100. So we have a long history of dealing with cannabis policy in this state, and I think it's better understood. I don't think this nascent industry is understood at all by most folks, including me at the top of the list. So I just think that the questions that you just posed, Corinne, are going to be key questions that local government clients are going to want some answers to. And right now I've got no answers for them.
Right.
Well, I feel incumbent now to try to educate you a little bit, Rob. Although I'm not the best one on this call to do this. I think folks who are on this call who have businesses in mind are more knowledgeable than I am, me just being a lawyer. But I have been asked by a number of folks, what will this look like? What will a manufacturing facility look like? What will a service center look like? I disclaim everything and say I'm only a lawyer. I don't, take it for a grain of salt. But I will say this: a manufacturing facility for psilocybin, first of all, by statute, cannot be outdoors, right? So we have an indoor thing. So you're not going to have an outdoor farm like we do in cannabis. I'm also told by more knowledgeable people that overall, the market for psilocybin products is going to be a small fraction of what the cannabis market is. I'm told that, a couple decent sized warehouses could supply the entire state for a year. So I just don't think the sheer number of manufacturers will be that voluminous. I don't know how many licensed cannabis producers and processors we have right now, but it's in the hundreds and hundreds and maybe approaching 1,000. So it just, I don't think it's going to be anywhere near that. If it is, nobody will make money, and the price of products will be pennies. Service centers, I think, are a completely wide open possibility. If you go on YouTube, you can sort of see these videos of the clinical studies that are being done at, let's say, Johns Hopkins, and it's a small little room with a couch or a bed, and somebody's lying there with eye shades on, listening to music under blankets while somebody's holding their hand, and it doesn't look like it's a lot of real estate. They're in what would be like a counselor's office or something. So that may be like kind of one end of the spectrum, but I think the service centers could look wildly different. They could. The OHA, there's a reference in Measure 109 to outdoor administration sessions. So you can consume, a client could consume a psilocybin product, and during the experience phase of that, wander outdoors. It's still on the licensed premises. Now, I don't think the OHA hasn't promulgated those draft rules yet. The OHA could say everything has to be indoors, or they could say it could, you could have outdoors. Hopefully they're going to say outdoors, but that's a different thing, right? So you could imagine a larger, at the other end of the spectrum, I think you could have a pure destination, high-end resort with a whole bunch of bells and whistles, with an outdoor facility, and it's wildly different than a little 10 by 10 room with a bed in it. So I think it's just that the service centers will depend on the creativity of the folks who are starting service centers, combined with what the local jurisdictions will permit. Psilocybin and a variety of other psychedelic substances are legal in other countries, and so you could fly to the Netherlands. Psilocybin is legal in Jamaica. A variety of South American countries have a variety of legal psychedelic substances where folks can go down to and participate in ayahuasca ceremonies and things of that sort. But I know in Jamaica, like they were flying down people, and people would stay at these, basically resorts. It's like an all-inclusive resort in Mexico or something, where you're there for 4 or 5 days and you're participating in a couple of sessions and you're doing a whole bunch of other things. So you could, that would be the high end of the spectrum. And I think it could be anything in between. So I think the variety of it is potentially broad. Whereas, I've been in a lot of cannabis dispensaries, and there are some really nice ones and some kind of shabby ones, but at the end of the day, it's kind of a store. This, I think, would potentially be somewhat, they could look wildly different. And I suppose it's a combination retail, when we say services, I think from the client's perspective, and it's an experience that's being had here, right? Like this is not just the whole experience of being there is something kind of, I don't know if there's a precedent for this, and that's why it might be unique. But that's, others can chime in as to what they might have in mind from a business perspective or what they might envision. But I think it's tough to pinpoint and have a picture of something and say, that's what a service center is going to look like. So I think we'd have to have like a dozen different possible pictures.
And I would just add this, in some ways it is retail, but it's not retail in the sense you're going to go in and buy something and then take it home. It doesn't work like that, whereas in cannabis it does. So I think you're right. That which is why I was glad to accept your invitation, because quite frankly, I wanted to hear you say what you just said, and I would love to hear from anybody else who has an idea what these things are. Because when I read the statute, it's like, okay, well, I'm not sure what category to put this thing in, and it could be a bunch of them, I'm guessing.
That's right. That's right. And we're almost done here, so we can open this up for comment in just a minute. But for the local government folks here, I just wanted to clarify that, Dave had said the term destination resort, maybe not knowing that that is a term of art. And so what I'd really like to focus on is maybe thinking about some of these psilocybin service centers on the spectrum of a wellness center or a wellness retreat, not the statutory destination resort.
It's like a spa in a way.
Right.
But then again, that's another category. And again, there's 36 different counties with 36 different categories of stuff, and 241 cities with 241 different categories of stuff. So I think what planners are going to probably wind up doing, over the summer is looking at their own codes and seeing if they need any changes. And again, this gets back to, I'm harping on the same thing. It's going to look different in different places.
Right. And I think that what's timely about this discussion is that operators, you can get in on these discussions at the local government level, and you should. So let me finish up here with our slides about, how you can participate. There are public meetings and public hearings for all of these procedures that a local government may use for a ballot initiative, to amend their land use code, to add certain uses to different zones. There's public hearings for a local government to be able to adopt time, place, and manner regulations for manufacturers or psilocybin service centers if they choose to do so. And last but not least, if some of these amendments happen in a manner that you don't agree with, there are opportunities to appeal. And so our takeaways here are, really on the operator side, the takeaway is just to realize that in addition to state laws that you might be subject to under the OHA, you're also going to be subject to local government regulation, at least for manufacturers and service centers that require a tie to real property. And so now is the time, there is time to educate local governments about what your business is and how it functions and where you might need to be located and why, and how it makes a difference to you and your business in this industry for the types of property that you need to be located on. Participate in local government land use processes. That's the only way that the local government is going to be made aware of your comments and how your businesses work, and be able to make an educated decision about where these businesses should be located and what sorts of regulations might apply. And for both sides, both on the operator side and for local government, collaborate together. We can incorporate these Measure 109 uses into the communities, I think, in thoughtful and considerate ways that can better every community. So that is our presentation. Thank you so much to Rob Bovett. Here are our emails, if anybody would like to email us. And Rob, unless you have any final thoughts, you can give us your final thoughts, and then we'll turn it over to Sean to see if there are any questions.
No, my final thoughts are the same as my beginning thoughts. Thank you for inviting me to attend here and participate in this. I think this is the beginning of a conversation. And again, I would encourage folks that are interested to kind of watch what's happening over the summer and the fall, because again, I think a lot of decisions will be made over the summer and fall about how 109 looks statewide.